Hi, my name's David Taylor. I'm a principal of the firm Segelov Taylor Lawyers. This is a short video about the process involved in bringing an unfair dismissal claim. If you're eligible to bring a claim, you need to do it within 21 days, so the application has to be filed within 21 days. Once it's been filed, the Commission will then send it to your employer and they'll have a period of time to file a reply. There's no obligation on them to file a reply, although in most cases they do. After their reply has been put on, or even if they don't, the matter is then set down for conciliation. There's one exception to that where there's a jurisdictional objection, which I'll cover in a second, but by and large the next step is that it's set down for conciliation. A conciliation is run by a member of staff of the Fair Work Commission, not a judge type person, just a person employed to assist in trying to resolve the matter. The conciliation's confidential, lasts about an hour and a half, done by phone. At that point, there'll be a chance for you or your lawyer or representative to put their side of the story, the employer to do the same, and then there's an attempt to try to negotiate a settlement. Matters that settle at conciliation, and most matters do, generally settle for something in the range of 6, 8, 10, 12, 14 weeks pay. If the claim's very strong, it might be more. If the claim's weak, it might be less. In addition to the payment, there's also generally a deed, and the deed will set out a range of normal terms which involve releases. You can't bring any more claims. Non-disparagement, which means that you can't say anything rude about them and they can't say anything rude about you. Confidentiality, you can't talk about what happened and how much they paid or any of those things. And that's pretty much it. If the matter doesn't resolve at that point, it's set down for hearing. I mentioned before that there can be a jurisdictional objection. A jurisdictional objection is where the employer says, well, hang on, you weren't entitled to bring a claim. The jurisdictional hearing can be heard before or after the conciliation, and that's really up to the employer. And it might be the employer says, well, look, you weren't employed for 6 months, or you earned more than the high income threshold. Those are criteria, and we've done another video about when you're eligible, so if you can have a look at that around that. The jurisdictional hearing is heard by a member of the Commission, and they'll say, yes, the claim can proceed, or no, the claim can't proceed. And that's sort of a threshold point to move on. If you've gone through the jurisdictional hearing, if there is one, and you've gone through the conciliation, the next stage is to prepare for a final hearing. Before the final hearing, you put on documents and evidence, so statements saying this is what happened, and any other workers who might have been around who can say this is what happened, along with submissions, where you set out why you say the dismissal was unfair. The employer does likewise, and then the matter is brought before a member of the Commission. Most matters and an unfair dismissal take about a day, day and a half, plus or minus to run. During that time, anybody who was there and who has evidence to give is called, and they can be cross-examined. They can be asked questions about their evidence. After that, there are formal submissions made where you describe why it is that the dismissal was unfair. And then the member will what's known as reserve generally. That means they'll go away and they'll think about it for a while before coming back, usually weeks, months later, with a written decision saying, yes, the dismissal was unfair, no, the dismissal wasn't unfair. In the decision, if the dismissal was unfair, they'll also make a decision about what sort of remedy there should be. Now, the remedy can either be a reinstatement or, more commonly, compensation. There's another video about remedies and how that all works, and you can have a look at that.